Talk shoes. Recorded live.
All right. Well, this is Matthew. Welcome to the call, everyone. This is our regular scheduled Wednesday night call. And before we get started tonight, I'd like to welcome everyone, and I'd like to do a quick disclaimer. And that disclaimer is that the information that you are hearing tonight is for entertainment purposes only. It's for educational reasons. We are not attorneys. We are not tax advisors or tax accountants. We do not give legal advice. Anything you hear on the call tonight, you are hearing for your own edification, and you can take it and use it in whatever capacity you see fit. But if you do decide to use this information, I would encourage you to take ownership. I'd encourage you to read and study and vet out this information. Make sure that what we're sharing is legitimate, is legal, is obviously we're not doing anything to subvert or break the law. If you do hear something on the call that is not legal, I'd encourage you to bring it up to us so that we can correct anything that we're doing that is incorrect. We do welcome that. So, with that said, what I'd like to do at this time is go ahead and turn it over to Christian Walters, and I'm just going to mute out some of the other callers here on the call. So, Christian, if you're ready, you can go ahead and take it away.
Okay, thanks, Matthew. I'd like to welcome everyone to this November 11th show. My name is Christian Walters. I'm the host of Money, Banking, and Trust by Moving Titles and Commerce on every Saturday at 7 to 9 p.m. Eastern Time. And if you'd like to join me on that call, the access number, the number to call in is 712-432-8773, and the PIN number is 179441#. And that can also be accessed off the internet at therealpublicradio.net. So I believe we had the server down last week, and it's probably going to be down this Saturday, I guess. So if you can't get access through the internet there, you'll have to call in with the call-in number. And that number, again, is 712-432-8773, and the PIN number is 179441. I'd like to thank everybody who might have been on that last Saturday show, because that was really the formal announcement of a new technology that I brought out. It's called NTT, which is New Trust Technology. I'd like to thank all those people who joined me on that call and requested emails, because I was giving out a free complimentary copy of that last show for going over and review. So if you want to request a copy that I can send to you, you must send me an email at movingtitles@hushmail.com and request a copy of that, and I'll put you on the email list when I send out the link for downloading, so you'll get a copy of that. And we're getting a lot of response back on this new technology, NTT. It's really groundbreaking, and it's something that I don't think anybody is really focused on other than maybe just mention it. And what my total thing now from here on in is to utilize NTT as New Trust Technology, which rides on the platform of Moving Titles and Commerce. And that's everything we've been talking about on my main show on Saturday, which is the platform which NTT rests on, which is basically moving titles, how to claim a title, how to create a title, how to move a title. But basically NTT is really a total revolutionary new idea of looking at trust at all the time, inside and outside. Because everything that you do involving your signature is a relationship, and you want to determine what kind of relationship that you have, whether that's a trust relationship, a fiduciary relationship, or an agency relationship, or a debtor-creditor relationship, or others like administrator or grantor or whatever. Whatever. So the important thing is the key to the signatures, and that's the key to expressing what kind of relationship that you have, as well as qualifying that as to whether it fits the elements of a trust or whether it's just another relationship, say like fiduciary or debtor-creditor. because the four elements are necessary to form a trust that the law will recognize as a trust. And no party in the trust needs to know or understand they are forming a trust. And that's the grantor, the trustee, or the beneficiary. At that moment, they might not have any present knowledge or understanding of what they're doing, but that doesn't negate the fact that they are forming a trust, even though they didn't know it. If the law recognizes the elements that are there necessary for a trust, then a trust has been created. Now, there's how they're getting you, because everybody's saying, I never signed up for this straw man stuff. It wasn't my intent. I really didn't know anything about it. Well, I didn't understand it. Well, you don't have to under trust law. Trust operates solely in equity, and that's where the courts of equity finds its conscience to enforce the trust. And the big thing about the trust is the most determining factor is if the beneficiary makes a prima facie case, the burden of contradicting it or showing a defense will then shift to the trustee. And the burden of proof issue is one of the most significant distinctions and characteristics about trust law. There is no obvious transition from the threshold burden phase to the substantive burden phase. So, however, when a party claiming trust is the beneficiary, what happens is what is referred to as a shift of the burden, and thus where it is the beneficiary who is asserting the trust. And keep in mind, he who claims trust must prove trust. So whoever files the suit or the claim, because the threshold of burden of proof is on the beneficiary, then once the beneficiary satisfies that threshold of burden and the burden of proof shifts to the alleged fiduciary, or the trustee, in other words. So what does the trustee then have the burden to prove? The trustee then has the burden to prove compliance or non-breach, and he has no evidence that he can prove that. Because why would the beneficiary come forward with a claim stating that he didn't get paid when the trustee would have evidence to prove that he did? So at that point, here about the evidence is the burden of proof is that once the threshold of burden is satisfied, the law of trust presumes that the trustee is wrong or is guilty or has breached the agreement, as it were, and the fiduciary or the trustee has to prove that what he did was consistent with the application of the trust agreement by the grantor and with applicable trust law. And thus, in civil or commercial context, a trustee is quite literally presumed guilty. And he's presumed to have breached, and he must prove that he was within the terms of the trust and within the applicable trust law, that is, not guilty. And he can't do that without proof of a performance which he didn't do. Well, that's what makes trust so powerful. There's the slide or the transition from the threshold into the substantive burden phase, and you don't even know what's happening because it's so invisible, so to speak. But again, whoever claims trust must prove trust. So if you're in court saying about the Sesta case, aka straw man trust, and the judge says, hey, there's no trust here, I don't see a trust here, well, that's your barn door opening to drive a Mack truck through, because now you're claiming trust, and now you must prove trust. So you better be able to prove trust before you claim trust. Get that NOI coupled with the SOI, that you have real facts to support the claim that you are the grantor and the beneficiary in a case. Okay. Sounds like a lot of background noise on there. If anybody's not talking, why don't you just mute out?
I'll get that cleaned up. All right, you should be good, Christian.
Okay. Last week we were talking about, what were we talking about last week?
We were talking about the res, weren't we?
Let me turn back here where we started. Yeah, trust property res, we talked about that. And tonight we want to shift into the parties to the trust. We want to go into a little more detail about that. And I am reading from Gilbert's Law Summaries. It's entitled Trust, and it's by Edward C. Halbeck, Jr. And it's a $25 book. It's a very good basic book on trust. And I would suggest everybody for that price go and get it and start reading it. We're probably talking about a lot of trust terms that are probably new to a lot of people, but until you know what the definitions all are, you're going to be left in the dark, and you might have a little bit of catching up to do. So, but anyway, I'd suggest getting that book and also maybe doing a study at the law library on the restatements of trust law, the second and the third. And you might want to do maybe a Google search for the UTC, which is Uniform Trust Code. That'll give you some outlines to some guidance in that. And also maybe check your local states, say like Florida Trust Code or California Trust Code, but punch in your state and then type in Trust Code and see what pops up and see if your state has anything on Trust Code. Okay, so parties to the trust, and there are three parties to the trust, and that would be the settlor, the grantor, and the trustee. The settlor and the grantor are one and the same, and then the trustee, and then there's the beneficiary. So there's the three parties. So the settlor or the trust or the grantor. So in general, the person who owns a property interest may create a trust with regard to it and become the settlor. And next comes capacity. The settlor's legal capacity to create a trust is measured by the same standards applied like most non-trust conveyances. Thus, a settlor of the testamentary trust must have testamentary capacity, and a settlor of an inter vivos or a living trust must have capacity to make a similar type of non-trust inter vivos transfer. So the settlor of a revocable inter vivos trust must have a testamentary capacity because such a trust is considered to be a will substitute. The settlor of the donative irrevocable inter vivos trust must have gift-making capacity, and the settlor of the trust established as part of a commercial transaction must have contractual capacity. And under capacity, number one, voidability. Legal disabilities, example, minority or mental incompetency, may render the settlor's act void or voidable with the same consequences as any other void or voidable conveyance under appropriate local law. And under some circumstances, trust may be created or amended by conservators or holders of durable powers of attorney on behalf of settlors under disability. Now, that's a good read right there. If you can think about that, it talks about mental incapacity. Now, if you've done some study into the straw man stuff, you know that the court treats you as an incompetent. And if you're a straw man is really a fiction who is dead and has no mental capacity. So that is a legal disability. That may render the settlor's act void or voidable. So under the circumstances, it says trust may be created or amended by conservators or holders of durable powers of attorney on behalf of settlors under disability. So if your settlor has a disability due to an incompetency, aren't the courts construing that they're incompetent and everything that they've done is void or voidable? Working under a secret trust? So under capacity, now number two, qualifications. So in general, to have testamentary capacity, the settlor must, number one, be of legal age to make a will, and number two, suffer from no derangement, insane delusions, in other words, like, hey, I'm a straw man, I got a trust and everything. Isn't that what they kind of do to you? So suffer from no derangement that affects the testamentary disposition, and number three, be able to understand the nature and extent of her property, the natural objects of her bounty and the interrelationship of these, and to formulate and understand the disposition she is making. The settlor of a donative irrevocable inter vivos trust must meet the gift standard which is generally less settled than the will standard, but which is probably the same for wills with respect to mental sufficiency and freedom from derangement affecting the transfer, and further requires the ability to understand and likely effects of the irrevocable transfer upon the future financial security of the settlor and dependent family members. Sounds like maybe that might be what they're doing to us. We don't quite have the qualifications because we don't have the capacity, because we're not understanding the nature and extent of the property and affecting the transfer and the ability to understand the effects of that transfer. So the courts are construing it and twisting it around because we do not know. We do not have the knowledge nor the understanding. And that leads to voidability. And that all comes under capacity. So now we'll jump to the next section, which is rights. Rights in trust property after creation of trust. So once a trust is established, in other words, by expressing the trust, the settlor generally has only such rights or interest in the property as are reserved by the terms of the trust. So the settlor has no rights or interest unless it's reserved by the terms of the trust. An example, most commonly, a retained life estate or the express power to revoke or modify, or both, or by operation of law. And hence, complete title vests in the trustee subject to equitable interest, which is beneficial rights and powers of the beneficiary, conferred upon the beneficiaries, who may or may not include the settlor depending on the trust terms. So under rights, number one, the modern view, revocability presumed. So under the UTC and by statute in several non-UTC states like California, where inter vivos trusts are subject to revocation unless expressly declared to be irrevocable by the terms of the trusts. And now, number two, revisionary interest. Even where no rights have been expressly reserved by the settlor, if the trust or some interest in it is invalid, the res is excessive for the trust purpose, or the equitable interests have not been completely disposed of, a resulting trust exists in favor of the settlor by operation of law. And I've mentioned before, that could be used to your advantage. The resulting trust that's going to exist in favor of the settlor by operation of law. Example of that would be, you do a trustee appointment to the judge, say, and the judge just sends the documents back to you, or he says, I don't accept this appointment, or he disclaims, in other words, and he's going to take and tell you that he's not going to be the trustee. Well, that's fine. At that moment, a resulting trust forms where he must now do a successive trustee appointment, appointing someone else the trustee, and then he must notify me as who that new successor trustee is, because the property, the trust property that he was given now reverts back to me who issued it as settlor, and I hold it as temporary trustee until I get the name and address of the new successor trustee and then transfer the property to the new trustee. Because that is an equitable duty of the court. Under the equity side, equity will not allow a trust to fail for a want of a trustee. Just because the judge says he doesn't want to, a resulting trust is formed where he must appoint a new trustee and let me know who it is so I can give them the trust res. And that all comes about if you express the trust properly from the beginning. Because if you didn't express the trust properly from the beginning, you drop the ball and you allow them to construe it as something else, and they're going to construe it as being under debtor-creditor law, and now you owe a debt, and most trustees are in prison for owing a debt. So continuing on. Number three, mistake or misconduct. And we can reform a trust under mistake. So it says a trust may be set aside or reformed for fraud, duress, undue influence, and other misconduct, or for mistake, essentially upon the grounds as other donative dispositions. So if it was a mistake because the court construed what they thought I meant, I'm coming back in and saying, you're mistaken, you didn't do it right, I'm going to tell you the way I want it. So number 4, no right of enforcement in the settlor as such. So unless the settlor has retained beneficial interests in or powers over the trust, so in which she or he has the enforcement rights of a beneficiary, the general rule is that the settlor has no right to bring proceedings against a trustee or others for enforcement of the trust. And this is because the settlor, as such, has no interest in trust property. And is Meyer out there tonight? Because she's asked me some different questions about, what time do we want to be grantor and beneficiary versus times we want to be grantor and trustee. And I keep saying to her, well, in court we want to be grantor and beneficiary, and out of court we want to be grantor and trustee, and this is the reason why. Because in court, the settlor has no right to proceedings against a trustee or others for enforcement of the trust, and this is because the settlor, as such, has no interest in trust property. Now, caveat is, unless the trust has been misconstrued as to the intent by the mistake of the one we read above in number 3, where it could be reformed. Now, that brings in another good example of on these mortgage foreclosures, they always have usually a reformation of the deed or a reformation of the note. Now, the question is, was the reformation of that deed or the note as per the trust? Well, I'll guarantee you there was no trust even specified. So they're going to construe it under debtor-creditor. So why is the grantor, and what is his intent? And who is the beneficiary, and what is his claim? And was it a mistake or not? Prove the parties, and then express the trust intent, then reformation was not the intent, because it was a trust instead of debtor-creditor. Next section, settlor's creditors. So whatever beneficial interest the settlor retains, example, a right to income for life, may be transferred by her and can be reached by her creditors. So even if the trust provides that the settlor is entitled only to such income or principal as the trustee, in his discretion, deems appropriate, case law, numerous statutes indicate that the settlor's creditors can reach the maximum amount the trustee could permissibly distribute to the settlor. And then on number 1, under that settlor's creditors, under exceptions, asset protection trust. A number of states have enacted asset protection statutes that, in some circumstances, deny creditors access to settlors' retained discretionary interests. And you might want to see Delaware Code Annotated, Title 12, 3570 through 3576. And the number 2, retained powers. Creditors cannot reach the trust estate simply because the settlor reserves the power to direct the trustee regarding investments or distributions to others. If the settlor has retained the power to revoke, however, the cases are divided. Despite the rule as a retained discretionary interest, and despite many cases holding that creditors can reach trust properties over which the settlor holds a general power of appointment, the traditional view of most courts has been that the settlor's creditors cannot reach the corpus of the revocable trust, because the incongruity of the rule in light of analogous principles, the distinct trend of cases and legislation is to allow such creditors to reach the corpus, and there's some case sites to support that. And then this is also the view of the third restatements, section 25, and the comment E, and also the UTC section 505A1, and it has long been the rule in federal bankruptcy. Next section, fraud. In all states, creditors of the settlor can reach the trust estate if it is shown that the trust was created by a transfer that constituted a fraud upon the creditors. The fraudulent conveyance is one that is made without adequate consideration by a person who is or who is thereby rendered insolvent, or who made the transfer with intent to hinder or defraud her creditors. Now, my question is, isn't the straw man insolvent? Next, parties, trustee. So now we talked about the settlor or the grantor. Now next we're talking about the trustees. And the qualification. Any person or entity who has capacity to acquire or hold property for his own benefit and has capacity to administer the trust may be a trustee. So statutes limit the right of some persons or entities, example foreign corporations, to serve as trustees. And under number 1, capacity to take and to hold, or to have and to hold, and look that up in Black's dictionary, have and to hold, and you all thought you were getting married. Oh, wasn't it such a nice thing to have and to hold? So look up Black's Law, have and to hold. I forget what it's called. Hammurabi Code or something like that, they call it. So in the absence of statute, anyone who has capacity to acquire or hold title to the particular property for his own benefit also has capacity to receive property as trustee. So at common law, partnerships and other unincorporated associations were regarded only as an aggregate of their members rather than a separate entity. And the association itself, therefore, could not hold title to property or qualify as a trustee. So nearly all states today, however, recognize a partnership as an entity apart from its members, and thus a partnership can hold title to property, can serve as a trustee. And even in states that still follow the common law aggregate theory, the conveyance to a partnership may be construed as one to the partners individually. Now this brings in some personal experience that I have with a case that we're talking about an association who did a implementation of a foreclosure action for a mortgage property for association dues. But the captioning on the parties on the case and on the complaint was an association, Inc., or in other words, a legal entity. But the PUD, the Plan Unit Development Rider that was attached to the security agreement and mortgage, the title on that was not the Association Incorporated. It was just plain association. It was just a name. So at common law, partnerships and other unincorporated associations, which was what the actual rider contained, an unincorporated association, were regarded only as an aggregate of their members. And the association made up the complex's membership of everyone who owned a house in the association. And the association was coming at this one party for back dues, but they weren't suing in the association's real name. They came at them under an association incorporate name, which was different entity. So again, I'll read this. At common law, partnerships and other unincorporated associations were regarded only as an aggregate of the membership rather than a separate entity, and the association itself, therefore, could not hold title to property or qualify as a trustee. Bingo. So, and just an unincorporated association cannot hold title to property or qualify as a trustee. They had to come at this party with an entity, an incorporated entity, so that it could hold title to the property and qualify as a trustee. We didn't know that at the time. That could be something that somebody else out there might want to use. Next comes capacity to administer the trust, number 2. The capacity to take and to hold as a trustee is not the same as the capacity to administer the trust, and persons who have capacity to take and hold title to the property as trustee may not necessarily have capacity to administer the trust. Thus, a valid transfer may be made to show to such a person to create a trust, but that person will not be allowed to administer the trust. That is, to continue serving as trustee. For example, minors or mentally disabled persons, there it is again, mentally disabled persons may validly receive property in trust, but because their contracts or their acts are generally voidable and because such persons are not likely to possess the required skills and understanding to perform the trustee's duty, they lack capacity to administer an active trust and will thus be removed by the court and replaced by another trustee. Do you understand what that says? Because I think that is how they're getting in this in the court, as I was mentioning a little bit earlier, the capacity to administer. If you are declared incompetent or mentally disabled for some reason, that's because such persons are not likely to possess the required skills and understanding to perform the trustee's duties. They lack capacity to administer an active trust. Now, don't they take over trustee duties for you and administer the trust for you? But yet you still have the actual title, and they remove the court and replace by another trustee, which ties in what I said at the beginning of the show. No party in the trust need to know or understand they are forming the trust. Well, they're incompetent. It does not negate the trust, though. And he who claims trust must prove the trust, and one needs to be able to prove the expression of the trust elements and has the burden of proof to do so. If not, there is no trust. All because you didn't express the trust because you didn't know or didn't understand, and you became incompetent because you were really supposed to know. We talked a little bit about the burden of proof issue is one of the most significant distinctions in the characteristics about trust law, because there is no obvious transition from the threshold burden phase to the substantive burden phase. And the trustee must prove. And what does the trustee then have the burden to prove? The trustee then has the burden to prove compliance or non-breach. But he can't. And equity deems him guilty, or the trustee is wrong or has breached the agreement. That's the presumption, even in civil. So the trustee is quite literally presumed guilty. So he must prove up the beneficiary, the trustee, the trust res property, the method of formation, and if he can't prove that up, then your trust was not expressed, and then the burden can't shift to the other party. So look at it another way. While it is indisputable that the trustee carries the burden to show compliance with the trust agreement, it's just as indisputable that such burden doesn't even exist until after the beneficiary carries the threshold burden to show that the claimant is the beneficiary of the trust and with trust res and managed by the alleged trustee. So he who claims trust must prove trust. And you must express the trust first, and the burden to express the trust is with you. So number 3, corporations, domestic and foreign, as trustees. Today, all states authorize the use of corporate trustees. And under A, common law, in early English common law, however, the courts refused to allow corporations to serve as trustees, in part because the chancellors believed that no power to compel creatures of the state to act, and also because of belief that only natural persons should bear the fiduciary duty of a trustee. And under B, foreign corporations. So in several states today, foreign corporations, that is, those incorporated in other states, are denied the right to engage in trust administration, or as it is often provided by statute, quote, to carry on trust business within that state. So however, such a flat prohibition, absent some jurisdictions, may be unconstitutional. In the case R.A. Shapiro, which was at a law review quoting here. So now number 4, co-trustees. Where 2 or more persons or entities are named as trustees, each must have requisite qualifications, and if one does not, the right to act belongs only to the one or the ones that do. And if the trust terms or purposes are construed as requiring a certain number of co-trustees for sound administration, the court will appoint essential trustee to replace the one who is disqualified or dies. And co-trustees generally deemed to hold as joint tenants with the right of survivorship. Now, next section, bonding. Although there was no automatic or presumptive bonding requirement at common law, statutes in many states require trustees of a testamentary trust to post a faithful performance bond, and more recent legislation tends to require a bond only if the court finds a need for it. So number one, the court may order a bond to protect beneficiaries' interests. So if courts of equity or probate or other appropriate courts generally have the power to compel the trustee or any type of trust to post a bond if a particular risk is demonstrated, or if the trustee is involved in litigation with beneficiaries in which there is a personal attack on the trustee. An example for mismanagement of the trust, or breach of fiduciary duty, or unclean hands, or whatever. Number two, the court may override waiver over the bond. This equitable power applies even where the settlor has expressly provided that a bond is not necessary if there is a direct attack on the trustee's performance or a material change of circumstances. Otherwise, the court properly will not order the trustee a bond where the settlor provided relief from bonding. The court will also relieve or reduce an otherwise applicable bonding requirement. And C, the effect of failure to name trustee or failure of named trustee to survive or qualify. The general rule is that equity will not allow a trust to fail for lack of trustee, quote unquote. That's under equity. Thus, if the named trustee declines the appointment, fails to qualify, or ceases to serve, or if no trustee is named in the trust instrument or the named trustee predeceases the testator, a court of equity will appoint a trustee. And how do they do that? I mentioned that earlier. A resulting trust is formed at that moment by an implied construment, and the judge will appoint a new successor trustee, because equity will not allow a trust to fail for lack of trustee. Number one, rationale. So this rule protects the settlor's intent and preserves the trust until the purposes are fulfilled. That's the sole thing. So it presumes that the entity of the trustee is less important than the carrying out of the trust purpose. Could read that one again. It presumes that the identity of the trustee is less important than the carrying out of the trust purpose, but only if you express the trust first. Number two, personal trustee cases. In rare cases, the settlor may express an intent that the named trustee is the only one acceptable to administer the trust. That is, a personal trustee without whom no trust is desired. So here the trust does not fail or terminate if the named trustee declines to accept, or is dead or incompetent, or ceases to serve. The court will not appoint a successor, though. Number three, says here, caution. Without trustee and intended, inter vivos trust may fail for lack of delivery. So it should be noted, however, that the absence of a trustee may result in the failure of an attempted creation of an inter vivos trust because of the requirement of a present and effective transfer. In other words, if there is no trustee, there is no one to whom delivery can be made. Without delivery, there is no transfer and thus no trust. Hence, the trust fails for lack of transfer and not for want of a trustee. And under A of that category, attempted transfer to trustee to be named in the will. Thus, an attempted inter vivos assignment to the trustee to be named in my will, quote unquote, fails for lack of delivery and for want of a trustee to pass the title to at the time for the purported conveyance. And with no effective transfer, there is no trust. B, trustees qualified. If there is an intended trustee to whom delivery with the request present intent is made, but the transferee is technically qualified by law from taking title, not merely disqualified from serving as trustee, the result is in doubt. A court may salvage the trust, possibly as a declaration of trust or by appointing a trustee, especially for the natural object of the transferor's bounty. But supposedly, quote, equity does not save defective gifts by treating them as declarations of trust, unquote. The question is unsettled, and the theoretical basis for a trust in such a situation is unclear. And see Scott on Trust, Section 31.5 and 32.3, 4th edition, 1987. Next, Section C, Testamentary Trust. This problem does not arise in connection with testamentary trust because no requirement of delivery exists. The transfer requirement is satisfied if there is a valid executed will and the testator dies. No more is required. If the trustee named in the bequest or divis is predeceased, lacks capacity, or disclaims, in other words, he refuses, or even if the trustee has been named, it says, quote, I leave my residentiary estate in trust for L for life and the remainder to R, unquote, the trust is nevertheless good unless personal to the named trustee, a trustee will be appointed by the appropriate court. And here's a little tip. It says, if you encounter a question in which the named trustee dies, refuses to accept appointment, or resigns, remember that the court will appoint a successor trustee unless it is clear that the settlor intended the trust to continue so long as the particular trustee served. However, an attempted inter vivos trust that does not name a trustee may fail for lack of delivery. Now, next section, nature of trustee's interest. Number 1, title to trust res. The trustee is said to have bare legal title, meaning that it is devoid of beneficial ownership. That is, the trust property is held for and on behalf of the beneficiaries in accordance with obligations of the trust or the trust indenture. A, the source of the title. The trustee of an inter vivos trust derives title from the trust conveyance. However, authorities are split on whether the testamentary trustee derives title from the decedent's will or merely nominated by the will and derives title by judicial appointment confirming that nomination. The question is relevant upon where someone seeks to block the trustee's appointment, and the question may affect procedural matters or whether the trust or the estate then has title. In any event, the grounds for blocking an appointment are ostensibly at least the same as the grounds for removal of a trustee. And now B, relation back. Acceptance of the trustee of a testamentary trust relates back to the settlor's death because the trust is treated as having been in existence from that date. So the tip here is the relation back rule is important to remember because it is impossible for a trustee by accepting to become personally liable on contract or tort claims arising prior to the time he accepted. Next one, C, quantum of estate. Usually the trust instrument will spell out the nature and extent of the title conveyed, and if it fails to do so, the court must determine the quantum estate transfer. Under the traditional view, such a case, the trustee takes title to real property only to the extent necessary to carry out the terms of the trust. And in the modern view, based on implied powers and duties of administration, as that the trustee takes and needs the full title that has been held by the settlor in both real and personal property. An example here, settlor deeds, quote, to trustee upon trust for beneficiary for life, unquote. Does the trustee have the fee or merely a life estate for the beneficiary's life? Under the modern view, the trustee will be deemed to hold in fee simple with resulting trust, that is an implied equitable reversion in favor of the settlor. And under the traditional view, however, the trustee will be deemed to have full title with resulting trust in favor of the settlor. So if the trustee's powers include power of sale, which is typically the case, or if the implementation of the trustee or the duties or powers otherwise requires full title, example, to encumber. So absent such express or implied power, the trustee may be deemed to have only a life estate for the life of beneficiary with a legal reversion left to the settlor. Number 2, next section. Trust estate not liable for personal debts of the trustee. The early and minority view here under A. A few states, based on a theory that beneficiaries only have a cause of action against trustees rather than equitable title, the trust res was subject to execution by creditors for personal debts of the trustee. The beneficiary's remedy in such states was to bring a separate suit in equity to enjoin the creditors by proving the beneficial ownership of the trust res. Now B, modern view. Under the modern view, however, the trustee has long been recognized in all states as having only a bare legal title, in other words, no beneficial interest, and hence the trustee's personal creditors cannot reach or satisfy their claims from trust property. Number 3, next section. Effect of trustee's death. A, death of sole trustee. Although the trustee has only a bare legal title, it nevertheless has title, and on the trustee's death, that title is generally deemed to pass to his estate subject to the trust, and thus trustee's heirs take no beneficial interest, and trustee's surviving spouse cannot claim dower, courtesy, or forced share in the trust property. Furthermore, the decedent's executor or administrator has no active administrative power over the property, but probably has the duty to protect it and, if necessary, see to the appointment of a successor trustee. The court will direct the transfer of title to a successor who then has power to administer the trust. It always follows the same rule. Equity will not allow a trust to fail. If the intent and purpose of the grantor or the settlor is there, then a court of equity will make sure that his will or his intent or purpose is carried out. It says, note, number 1, some statutes are contrary to provide on the death of a sole trustee, title is vested in the court or is suspended until new trustee is appointed. B now, death of one of several co-trustees. Co-trustees are presumed to hold title as joint tenants and with the right of survivorship. Thus, on death of a co-trustee, the title vests exclusively in the survivors. The law presumes, in the absence of circumstances indicating to the contrary, that the settlor intended to have the survivors discharge the burdens of the trusteeship. So if the instrument provides otherwise or the court finds contrary to intent, however, this presumption does not apply and a successor co-trustee will be appointed, and this may also be done if the court concludes that this is administratively more efficient or prudent. Example, where the surviving trustee has conflict of interest, often as a beneficiary. There could be a defense there. E, next section, disclaimer or resignation by the trustee. Now think about the judge being the one who has been appointed, and he's going to disclaim or he's going to resign. So the disclaimer, number 1, normally a trust cannot be forced upon a designated trustee. Now there's a caveat that says normally. So thus one who has not previously accepted a trust or contradicted in advance to do so can disclaim and refuse appointment as trustee for any reason or for no reason at all whatsoever. It is said, however, that the trustee cannot accept in part and disclaim in part. If he accepts it all, he is deemed to have accepted the entire trust. And this probably overstates the rule. The question likely turns on harm to the trust purposes or to a beneficiary. I'll read that again. The question likely turns on harm to the trust purposes or to a beneficiary who does not consent. So, for example, the lower courts routinely allow a trustee to accept the trust but to disclaim certain duties in a form of fiduciary powers that would have adverse tax consequences. Number 2, resignation. Once having accepted, accepted appointment as trustee, a person cannot merely resign unless the trust instrument gives this power or unless all beneficiaries consent. So unless the trust instrument gives this power or unless all beneficiaries consent. Ordinarily, the trustee may obtain an appropriate court order relieving him as trustee. Until then, he must carry out and perform all the various trust duties, and he remains personally liable for the consequences of any default in the meantime. In other words, if you're the trustee on this trust, you're liable, and you go to prison as a trustee. Now, under A, under resignation, the effect of unauthorized conveyance or the return of the res property. So that would be like the judge gives you back the papers of all the documentation and stuff, sends it back to you. It says nothing else. So he's giving an unauthorized conveyance, the reconveyance. The trustee cannot escape his responsibilities or defeat the trust by reconveying the trust res to the settlor. The purported reconveyance may be treated as a nullity, or at most, the reconveyance may effectively return legal title to the settlor, with the beneficial ownership remaining in the beneficiaries. The settlor would then hold title as constructive trustee for their benefit. This is a bingo. In other words, until the court appoints a successor trustee, so the settlor as trustee transfers the res to the new successor. And that's all done by the powers of the court in equity, because the court will not allow the trust to fail for a lack or a want of a trustee. Now, that can be used to your advantage. So how they get you by not expressing the trust, they construe you to be the trustee and personally liable. So B, when resignation becomes effective, even if the trust instrument permits the trustee to resign, the resignation usually is not effective until the successor is appointed. The common law notion of, quote, no gap in succession, unquote, is the interest of sound, secure administration required at legal title, that the legal title and duties remain in the trustee until taken on by another. The trustee assumes this obligation in accepting appointment initially. So F, next section, removal of trustee. Unless the settlor reserves power to remove a trustee or confers that power on some name or described beneficiary or beneficiaries, plural, or other person or persons, only a court of competent jurisdiction may remove the trustee. And under number 1, the grounds for removal. Numerous grounds for removal are recognized, but the basic criterion is whether the trustee continuance in office would be detrimental to the interests of the beneficiaries. Among the various grounds recognized are legal or practical disability, serious or repeated breach of trust responsibilities, and including the duty to cooperate with co-trustees and their duty to render accountings or reports, refusal to give a bond as required, commission of a crime involving dishonesty, and conflict of interest not contemplated by the settlor. And under A, insolvency. Insolvency of a trustee is generally not in itself a sufficient grounds for removal unless the court finds that the trustee's insolvency jeopardizes the welfare of the trust. And under B, animosity. Disagreement or tension between the trustee or one of the more beneficiaries is not grounds for removal unless the animosity jeopardizes the sound administration of the trust. And under C, the settlor-appointed trustee. Generally, the courts are less inclined to remove a trustee named by the settlor than one appointed by the court. This is particularly true if the alleged ground for removal, example, conflict of interest, was one known to or anticipated by the settlor. New section number 2 here, removal by beneficiaries. Removal by under the trust terms, the beneficiaries have the power to modify the trust or terminate it and compel the trustee to transfer the property to them. They have a power to remove the trustee directly because it is pointless to require them to change the terms of the trust or terminate it and immediately create a new trust upon the same terms with a new trustee. You want to compare the UTC under Section 706B4. Now, we're going to come to a new section here, merger of title. And I'm just going to touch on this a little bit, and then I think we're going to stop there and then open up for questions. So G, merger of title, where sole trustee is sole beneficiary. Where the trustee, in other words, the holder of the legal title, and the beneficiary, in other words, the holder of the full equitable title, or the beneficial title, are or become one in the same person, the legal and equitable titles merge, defeating the trust and creating a fee simple absolute in trustee beneficiary, who thus holds outright and free of trust. That's the termination of the trust. Number one under that, merger of title, attempt to decline trusteeship. If a sole trustee is the sole beneficiary at the outset, it may be argued that the merged titles immediately and no trust exists. Therefore, it is said the trustee beneficiary cannot decline the trusteeship and preserve the trust. But under the third restatement position, this is contrary. The reserved restatement, the third, section 69, comment D. Now, number two under merger of title, non-identical interest. Where the interests are not identical, as where the trustee does not hold exactly the same quantum of interest, legal or equitable, there is no merger. This arises frequently where the multiple trustees who are also beneficiaries. So as a general rule, the existence either of multiple trustees or of multiple beneficiaries or both precludes merger. We don't have that far before we actually finish this because it's going to start on beneficiaries next. So example, obviously the scenario, quote, settlor to son and friend upon son, trust for son, who is the nephew and the niece, unquote, involves no merger because the son's legal and equitable interests are not the same. Son has 1/2 legal interest and the 1/3 equitable interest. Another example, even if the conveyance is, quote, settlor to son and friend upon trust for the son and nephew, unquote, son's interest in trustee and beneficiary are still not merged, although the son is 1/2 legal and 1/2 equitable owner. So most courts hold that the son and the friend's joint judgment is necessary to the management of the son's interest as beneficiary, and the legal titles and duties of both extend to nephew's beneficial interest. In few cases, however, have been held that there is a merger with respect to son's equitable interest, the trust then consisting only of nephew's 1/2 interest. Another example, quote, settlor to son and friend upon trust for son and friend for life, and then to nephew and his heirs, unquote, involves no merger, and each co-trustee holds for the benefit of both during their joint lifetimes. When the first co-trustee dies, a court might hold that there is then a merger of the life estate in the survivor. So, however, this result is dubious at best, and in a conveyance where, quote, the settlor to the son and his heirs upon trust for son for life, remainder to a friend, unquote, might suggest a mere merger of son's equitable life estate into the life estate of the son's legal fee, creating a trust only of the remainder interest as possible, not what is intended, because son's legal and equitable titles are not equal, and there should be no merger, and active duty should prevent execution of the statutes of A. No merger where several trustees are also beneficiaries. So, quote, where the settlor to son and daughter upon trust for son and daughter, unquote, creates a valid trust, in other words, no merger. The settlor probably intended son and daughter to jointly manage the equitable interest of each, that is, each co-trustee to hold for the benefit of both. And again, some authorities have disagreed, arguing there should be a merger in this situation, the quantum and nature of the estate being identical. So probably the question is better viewed not as a technical one of merger, but as a question of attempted termination by consent of all beneficiaries. Example, under the Clayton Doctrine, it is applicable to the jurisdiction. And B, a note, some statutes now confirm that intended declarations of revocable trust are not defeated by merger. And C, comment, controversy over whether a merger takes place or arises most frequently when a creditor is pursuing the beneficiary's assets. The creditor will argue for merger so that she can satisfy her claim out of the beneficiary's legal state of the estate, or legal share of the estate, which is usually more practical and effective than attempting to levy on the beneficiary's equitable interest. And now the next section is going to talk about the last, which is the beneficiaries, and that's where I'm going to leave it for the next show. And now we'll open it up for some questions. If anybody has any questions, what is it, star one? Get what it is.
Yeah.
State your name and where you're from.
Sorry.
I got a question.
Go ahead.
Chris, this is Darren. How are you?
Okay, pretty good.
I had a question in what you just stated. So, in other words, like if a judge resends documents back, at that time he has done an unauthorized conveyance, which is deemed a legal nullity?
Right. That's what it says.
I just sent you a sample of it to be sure. Now, when you say to prove the trust, what's the proper way to do that? Just the statement of interest?
Well, if you just come in with a notice of interest that claims that, hey, there's a trust here, you have the burden of proving that there is. And the only way you're going to be able to prove it is you're going to have to come up with some kind of prima facie evidence as to say that I am the grantor and I am the beneficiary in a case. So you're going to have at least an affidavit making a prima facie case stating such and such that you are the grantor, you are the beneficiary. But then I would also have the evidence ready to back that up.
Okay, so if it was you, how would you do it? Just a hypothetical.
Okay, if I'm going to come in and say there's a trust here, which is my notice of interest, I got to follow up maybe simultaneously or at least at a later date within 30 days, or else this NOI is going to time out. I got to have the SOI, which is the material facts. So first I'm going to put in there, I put an affidavit in there which is going to set up the prima facie evidence that I'm going to state in there that I'm the grantor and I'm the beneficiary. Then I'm going to make sure that if I don't have the evidence, then I'm going to have to quickly get it. And how I'm going to do it is I'm going to reapply for Social Security if I haven't done so already, and I'm going to get an SS5 application and sign that application by grantor. And I'm going to make a copy of that and give it back to the Social Security Administration. I'm going to keep the original, which is the rule of form. I keep the original. You might not have a chance to get that through to them, but there's other ways of doing that by notary presentment. It doesn't make any difference whether or not they accept it or not by refusing it. If you mailed it to them by transfer and they got delivery under UCC 1-202, they got notice.
Okay. Just on the, I'm sorry, but you just brought it up because I have it right on my desk as an SS5 form. Now, my question is, which of course it does talk and refer to citizenship, which I don't like that term specifically because I believe the term citizen always relates to allegiance to. Can't you state that you are, in technicality, a Native American because you are native to the American soil or as a territory?
Yeah, you're like an Indian. You're like an Indian.
Christian, isn't that question asking about the straw man, though, not the living soul?
True. Right.
Wouldn't the straw man be the 14th Amendment citizen?
Here's the thing. If you're under debtor creditor law, UCC law merchant, you're under the 14th Amendment citizen.
So
you're under debtor creditor.
Wouldn't the correct response to that be that you would say, yes, I am a U.S. citizen?
But trust is not. Trust is in equity on the private side of the court, which is where equity, where the private rights of the substantive man is that's where it's at, in chambers, on the private side of the court.
But I guess what I'm wondering about is the SS form itself, where, of course, it starts out, and I think it's the all-caps name under one, then you have a mailing address, and it says citizenship. And I'm curious in regards to the proper way to fill this out, because in technicality it is a contract. So the question is, are you the strawman U.S. citizen, or are you the living, breathing soul Native American?
Well, there's where the split comes in, because, the straw man is a 14th Amendment citizen, but he can't speak, and I must speak for him, but I'm going to speak for him in a qualified manner by signing as grantor. So I would maintain my position on the equity side as the real man on the land, representing this trust, this straw man trust.
Right, but it has to actually be based on on the living soul, because it does ask for date of birth, race, place of birth. That can't be a non-living entity that has gone through that. So it has to be the living human man. But you're coming in as grantor.
That's my form. Everything on there is all fiction. Everything except the signature.
So how do we fill it out properly then? What would your take be on that?
Signed by grantor and the signature.
Is that something we could go over maybe on next week's call, Christian?
Yeah, that's the rule of signatures.
Well, I'm not so much interested about the signature. I'm more interested about how to fill out the boxes.
Okay, there's only one box on there, and that's the one where you say, you're a United States citizen. I think that's in block 3. You got optional boxes there. You can check that box where it says you're a United States citizen. Well, that puts you right under 14th Amendment's, straw man citizen.
Right.
So,
and it also puts you under as an alleged felon under Title 18, Section 911.
Yeah, but what I've done, I've gone on the right a little farther. It says other. And I've checked that other block, and then I've drawn up above that. I've put American in there.
Right, Native American, because you're born native to America.
Right, and then you go by the instructions on the back of the form. It says, what proof you have to prove up that status, and that's birth certificate.
Correct. Right. Okay.
So now once I've filled that form out, I keep the original, I make a copy of it, and I give it back to them, the copy.
Is it a color copy?
When I get the beneficiary card, I sign the beneficiary card by beneficiary. Then I make a copy of that, and I give them a copy of that, and I keep the originals.
So under 16, where you sign it, you sign that John Doe grantor. Do you put without recourse, or does that bring the UCC in?
I think if you just put by grantor, you don't need anything else.
Okay. Well, don't you put the grantor in the box to the right?
Oh, yeah, 17.
Yeah. You actually write the word grantor in there?
Yeah, the relationship area, but where I'm signing, so I'm going to put by grantor in my signature.
And just grantor, not authorized agent or beneficiary?
No, just grantor, by grantor and signature.
Okay. Fair enough. Very good.
All right.
Now, we got that SOI material fact evidence that I may need in court. And then the particular way that I put it in there, I'm not going to bring it back in on the public side of the court through the clerk, because if I do that, I'm going to waive it. I got to bring it in chambers on the private side.
And you can actually make any kind of like a certificate number, which would be the SS number on that form, wouldn't it?
To give it a particular number?
Yeah, well, the Social Security number, wouldn't that be basically your registration number?
Yeah, right.
Mm-hmm. Yes. Okay. Fair enough. Thank you, Kristen.
Then there's also the evidence that I went over on another show maybe, which was really UCC 3-105, where it's talking about the negotiable instruments, that it's the issuer or the signer on the note or the draft who sets up really the ownership, and tying that in with a U.S. bankruptcy court district in Nevada case, Joshua and Stephanie Mitchell, and that was a 2008 case. but on page 8, in the footnote, it says Nevada recognizes that parties may secure the performance of an obligation or the payment of a debt by means of deed of trust. Then it gives reference to Nevada Revised Code Statutes 107.020, where it quotes, it says here, that the maker of the note is the trustor. Now, that's a trust term. A trustor is the same as a grantor, the settler. And the payee is the beneficiary. So they're talking about a note here. Did you ever know that your note in a closing for a mortgage was concerning a trust? This comes out of a federal bankruptcy case, and they're quoting Nevada Revised Code, and it's stating that the maker of the note is the trustor, or the grantor, or the settler. And this revised code, 107.020, probably is comporting to every one of the 50 states someplace. And if you found that, that would be proof that you were the grantor on the note or the maker on the note under 3-105. That's the proof that you have the SOI material fact that you're the grantor to substantiate your claim on the NOI.
Are you ready for another question, Christian?
Yeah, Christian.
Yeah. What's your name? Where you
Christian, my name is Mark. We've talked before. I'm out in California, if you can hear me.
Yeah, Mark. How you doing?
Hi. Yeah, I have a question. When you were talking about the trustee, and a trustee couldn't serve because of legal disability.
Right.
Okay. And so therefore...
Sounds like a straw man, doesn't it?
Yeah, I understand that. But I have another special application, and I'm asking about this for. If a trustee has appointed a successor trustee that has if it has a legal disability or a legal incapacity, perhaps, that sort of thing, and I could go into a little more detail, but I don't know that I need to, and the trustee went into court to resign and have that successor trustee appointed, and the court went ahead and appointed the successor trustee, or acknowledged it, or whatever you want to call it, with no notice or anything to the successor trustee, and the successor trustee did not have the legal capacity or had a legal disability at the time of appointment, what happens at that point in time? If there's, in other words,
or resign, did he, waive it?
Well,
in other words, did he disclaim it? Because that's what we talked about tonight.
Well, what he did was said that he did not have the legal capacity to act as trustee unless there were changes made to the terms of the trust.
Oh, well, he can't partially without accepting all.
No. But he didn't have the legal capacity to accept it the way it was. And so but the court and everybody and the court and
right. Disclaim it if he wants. If he disclaims it, then the duty goes back to another resulting trust is formed again, and then by court order, the judge must appoint a new successor until he finds one.
Okay. Well, this really involves my son, and my question is, could he start a process, an administrative process, to compel the holder of the trust, the administrator of the trust, in other words, who's administrating it, not the trustee, but the administrator of the trust, an administrative remedy to compel the holder of the trust. No, that's not the right word. The administrator of the trust to release the property of the trust to a successor, another trustee.
Actually, the title is reverted back to the settler as a temporary trustee. The settler as a temporary trustee is really holding title to the property.
Well, if the settler, the trustee, is no longer alive? Because that's the situation.
The trustee died?
Absolutely. No, the trustor or the grantor or the settler, because that's what you mean when you say settler. That's the original grantor, correct?
Yeah. Well, if he's dead, if the original settler or grantor was dead, then it can't revert back to him. The court will hold it in trust then.
Okay. And so how would you get it out of the hands of the court per se then?
Well, the beneficiary needs to make a claim for the court to order a successor trustee to be appointed so that the trust res can be given to the new trustee, and then it could be or collapse the trust, or it's not collapse, terminate the trust so that the disbursement can be made to the beneficiary.
Okay. Well, one more question. That normally would have to occur in the state where the trust was set up, because that's quite a difference in where my son is, you know.
Well, where's the court action at?
It was in Pennsylvania.
If the court action is in Pennsylvania, that court probably took jurisdiction for the reason because the trust property is located there.
Well, it was not real property. It was personal property, of course. Okay. And the court just automatically made an appointment to somebody who did not have the legal capacity to be a trustee.
Okay, well, they have the right to refuse or disclaim, and when they disclaim, then the court should reappoint another successor trustee.
And the refusal went to the administrator of the trust. Probably not the right place for it to go.
The refusal went to where?
The administrator of the trust, to the entity that is administrating the trust. That the trust that holds the property, I guess is the way to say it. And if I'm using the right words,
formed or notified the court so the court could have, appointed.
Never did. They never did. When I say administrator. When I'm saying administrator, I'm talking about the public corporation where the funds were or are never did anything about anything at all. Just assumed that everything was fine the way it was, even though they had been notified of the fact.
If somebody made a claim to otherwise, then yeah, it's going to stand. So you need to make a claim.
Well, but what I'm saying, as a beneficiary, the claim can be started, but does it have to go to that court in Pennsylvania rather than wherever my son is in California?
I would notify the court there was an impropriety done, that the administrator failed to appoint, or notify the court that there was a need for a new successor trustee to be appointed.
Okay.
And then make sure that you notify all parties.
Okay.
Once you put an action in the court, then now it's up to the other party to state otherwise.
That would be, when you say the other party, you'd mean the administrator of the trust, or you mean the original trustee, or when you say other party, or the court, you mean when you say other party?
Well, the other party is the administrator.
Okay. All right. And then
you're going to claim in the court, and then the other party, being the administrator, needs to be notified also.
Okay. And but my question is, I was trying to get the jurisdiction out of the other state and into the state where we are, without having to do. I mean, to do something in another state, without being there is about the easiest thing in the world, unless it would just take a letter or something.
Yeah, you probably could transfer it. Yeah.
Transfer it to California and have the California court rule on it then.
Sure. Yeah. Mm-hmm.
Okay. Well, I may have to do that then. Because it's just ridiculous what's happening. Okay.
What's
thanks
the end result? What are you trying to get at?
Well, there's property or funds here that have been sitting there for 20 years that nothing's happened with, and so it's ridiculous at this point because the successor trustee cannot act on it. There's no way he can act on it, and there's nothing. It's just sitting there. And my son would like to be able to enjoy as a beneficiary, some of the benefits.
Well, the beneficiary needs to be, making a claim, or you need to merge the titles. Merge the titles into one entity, and the trust collapses, and then the beneficiary needs to collect them.
Oh, well, that merging the titles is I'm really not quite there. I understand the first part of things, but merging the titles is another kind of an issue, I guess, because I'm not clear on that procedure or what that would actually mean in a sense. So, well, I think I've got to do something that maybe tries to merging the title. Is that a court procedure, or is that totally administrative? Hello?
You know, it appears we just lost Christian. He must have gotten dropped off. He'll call back in here and jump back on and let us know when he's back on. But
okay.
To comment on that, if I understand correctly, what he's talking
about...
I'm sorry?
Please comment. Yes, please.
Yeah. If I understand correctly, what Christian was going to say was that collapsing the trust involves the grantor also naming themselves as the beneficiary and the trustee. And when you do that, when you declare that you're both the beneficiary and the trustee, that's how you collapse the trust. So
well, in this case, the grantor is no longer alive.
Okay.
Because we're not talking about, I mean, this is a little bit off topic in a way, because we're not talking about the trust that most of us are thinking about in terms of, you know, the government and the corporate entity and all that, the private entity and all that stuff. This is a normal kind of whatever normal kind of a trust that people think of. You know,
probably a statutory trust.
Well, it's a trust that was established, you know, as part of an estate. You know,
does it have an identification number?
Oh, it absolutely does in terms of where.
Yeah.
Okay.
And it's some type of statutory trust.
Okay, I'm back.
Okay, Christian, we were just kind of talking about how to collapse the trust, and I was talking about being the beneficiary and the trustee simultaneously will collapse the trust. Is that correct?
Right.
Terminate the trust, not collapse.
Yep, terminate.
Yeah, but in this case, it's the termination of the trust in that way that you're talking about, because this is I don't know who it was that was just helping me just now. I don't know who your name is. I'm sorry.
It's Matthew.
But, okay, Matthew. All right. So we're not talking, you were talking about this is more of a statutory trust, right?
If it has if it has a federal tax ID, it is a statutory trust.
As opposed to the kind of trust that the Express Trust, I think, or Sesticate Trust, or any of those things, I think, which is sort of the topic of the call, you know. But when you talked about the disability, the legal disability of the trustee, I began to think about that and try to see if there was a way that administratively even we could start to work with that, you know. And that's why part of the reason for my question at all.
And did the administrator say why he was incompetent or inability?
When you say administrator, I may be using the wrong word. The trustee has legal limitations on what he can do. Okay? There are legal limitations on what the trustee can do. So he cannot act in the capacity of the trustee. And the entity where the funds or the property was placed, a public corporation, has never recognized that incapacity and still considers that trustee to be the trustee. And the trustee says, I can't do this, and if I resign, I'm admitting I was the trustee. That's his position, and he won't take that position. And I can understand that. If he resigns as trustee, that would admit that he was trustee. He's not opposed to anything being taken away. He don't want any part of it.
Let me read you something here.
Please.
If there is a lack of any presumption of death or grant of power to pay a substitute, the trustee may pay the funds to any alleged successor of the absentee at his peril or hold them indefinitely. Sounds like that's what they're doing. Holding it indefinitely. Because, number one, this is the unknown beneficiary problem, and this could be a defense. Unknown, and then the alleged fiduciary or trustee has no duty to pay or the obligation to such a party because he doesn't know who the party is.
Well, the alleged, I want to call it alleged, supposed trustee definitely knows who the beneficiary is. So that there's no question about that part.
Well, then he just breached trust duty then.
Yeah, but if he had never had the legal capacity to be the trustee, is the point, and express that that lack of capacity to the institution where the funds were domiciled in.
Have there been any claims ever made against the trust into the court?
Pardon me, you broke up, so I missed what you said.
Have there been any claims into the court by the beneficiary?
None.
Well, then, what are you waiting for? That's your problem right there.
Okay. What I was saying was, what I was trying to get at. Go ahead.
Got to make a claim.
Well, now that my son is of majority age, I mean, it'll be a little easier, I think. But the problem is, I was saying was then where the court's located. That was my concern. To try to bring an action, thousands of miles away when, by correspondence or something, it didn't seem like that was very practical, in that sense. So.
Right.
I think the thing to try to do is in some way get it heard in California.
Yeah, get the venue changed.
Yeah.
Okay.
All right. Thank you for spending this time with me. I'll get off and allow somebody else to ask, another question.
Thank you for your questions. All right, Christian. We have another caller who typed up their questions and sent them to me, so I'm going to go ahead and read them to you. I asked the caller if they could dial in, and he said that wouldn't be possible. So the first question regards the necessity of a DIP hearing in certain cases, especially for criminal. So the question is, how many have been successful at being granted one that you know of? And before you answer that question, they stated they knew somebody in South Carolina who requested a DIP hearing, and they were denied. What is the effect on your process when you're denied a DIP hearing?
Well, you didn't have a hearing. You didn't have due process done. So if there was no DIP hearing, then, you didn't have a chance to present your information, your CCI information or your material fact or your SOI. So I would go back in there, and I don't know exact steps that they did to ask for a DIP hearing, but you should have been granted one pertinent to your case.
Absolutely. Next question on using the new trust technology for criminal actions. The caller is asking you to go into further details on handling it when the judge says, I don't see a trust here. Are you to be prepared with paperwork, or can you just simply stand there and make a declaration? So they're asking for some details on that.
Declaration is one way of method of proving, forming a trust, but then you have to have the four elements of the trust: the intent, purpose, parties, and specific trust res. If you have the four elements and you have one of the methods of formation, which is the declaration, transfer, and appointment, or the contract, then you have one of those, you've got a valid trust then. And it's up to the one who claims trust to prove trust, and once you prove trust, now the burden shifts to the other side.
All right. And the next question, please comment on the details of how to stand in criminal court and to destroy the presumption of a beneficiary there to provide a prima facie case against the trustee. What if the judge says that you're crazy? I don't know what you're talking about. This is frivolous, or they just carry on as if they...
Okay, well, here is something that we're doing. Let me make it clear that you really don't want to talk about this stuff in court. All this stuff has to be proved in chambers, because if you come into court and talk about this stuff, you are waiving it, and that's why they say what I'm talking about. And in particular, under Florida statutes, 90.50 90.506 and 50. Let's see. 90.506 is privilege with respect to trade secrets, which is our CCI information or our information, to our material facts to prove that we have a trust here. And 90.507 is waiver of privilege by voluntary disclosure. So if you bring this stuff in court, in open court, and you start talking about it, you have voluntarily waived the privileged matter of it. And you just lost your substantive right. So all this stuff has to be brought in on the private side of the court. It has to be brought in so that you can have an in-camera review of this information, this material facts, these SOIs. Otherwise, you're going to waive it.
Good point.
Otherwise, I'm sending you for a competency examination, and they're going to poo-poo this stuff up one side and the other because that's too much truth in the court.
All right. The next comment/question, it states that you're asserting through trust law research that a court/judge will not allow a trust to fail due to lack of a trustee, but this jeopardizes someone as the trustee in a criminal action goes to jail. So is he suggesting that rather than appoint a successor trustee, the judge will either dismiss the case or continue it and then make the action go away?
Well, you're not looking at the fact that you have been construed the trustee, and I don't want to be the trustee in a court of equity. I want to be the beneficiary. But if I'd been construed by an implied trust that was formed here because I didn't express the trust, that's the whole problem first. We didn't express the trust. We dropped the ball and allowed them to construe it, and it construed it to the point by the definition, by Black's Law, a legal definition of legal fiction, where it says that equity, a court of equity, is going to convert you by construement, by an implied trust, into a trustee. And I don't want to be the trustee in court, because if I am the trustee in court, that means I didn't make the payment. I'm presumed guilty already, as I went over earlier on the show here tonight. So once you are the trustee under construment, now you've got the duty to prove that you're not the trustee, that you're the beneficiary. How are you going to do that? Come back in and re-express the trust, because they made a mistake here. You've construed this improperly. Make a re-express trust, set up the parties being me the grantor and me being the beneficiary, have that evidence that I am the beneficiary, and now make the claim, the burden shifts to them as trustees.
And you do that in chambers?
Yes. And then, but notification in the public side of the court, though. Got to notice that.
The NOI?
Yes.
Okay, and then the last final comment here. So with this in mind, and you are standing there in a criminal action and you are being construed as a trustee and you want to resign, are you suggesting that as simple as creating a notice of resignation, perhaps sign under a notary witness and present it to the parties in support of the case?
Resign if they've got you as accepted, because you need a court order to resign. And they're probably not going to give you one or grant you one. It'd be better to come in and say, you've made a mistake on your construment, and I have the evidence to say otherwise, but yet all in chambers.
Got it. Beautiful. Great responses. Okay, next question coming from Bob. Bob, you've been unmuted. Are you there?
Hi, quick question. I know you're looking at the Gilbert's Law summaries. When I went to look at buying the book, there was a January 2000 edition and a November 2007, which I think is version 13. So I just want to double check which one that you prefer.
Well, I have the 2008.
Is that the copyright date, or?
Bob, what website are you at for that?
West Publishing. 2008.
Yep, copyright 2008, Thompson West.
Okay, so if I get it at West Publishing, I'd be okay then?
Should, yeah.
Okay,
that's all. Thank
Bob.
you.
Okay, last question is from Liar. You're there, Liar. You've been unmuted.
Okay, good evening, everybody. Chris, I sent you an email. Christian, I want to talk to you. First off, before I make my comment, what is the name of the book again? Gilbert's Law on Trust?
Gilbert's Law Summaries, Trust.
Law Summaries.
Gilbert Law Summaries.
Yeah, there's several different summaries, and this particular one is on trust.
On trust, okay.
Contract, too.
The other comment that I wanted to make or be sure of, to reiterate on something that was said earlier, because I want to make sure that there's no confusion in what I'm hearing. Everything you're giving us is your opinion from what you are reading and cannot be construed as legal advice because you're not giving legal advice. You're just giving us entertainment. Is that correct?
That's true, yes. Right.
Okay, I just wanted to make sure on that because I know some of the questions, as the way I address some questions put to me will always be, well, my opinion, but, the way you was giving them off, I wanted to make sure that you're not, giving legal advice, that you're only giving your opinion or something you're reading from whatever book you're reading from.
What I would do. Yeah.
Okay, that's all I have. Like I said, I did send you an email, and I talked to your buddy Barkley, and he told me definitely to sit down with you and talk. So I would definitely like to communicate with you.
All right, sure. Send me an email.
Moving
title at hushmail.com.
Moving title Hushmail. Yeah, I did earlier. I put I think I put the NTT in one block, and then I sent you another email. I think I put liar in it, so you would know it's me.
Okay. All right.
All right. That's all I have to say. Thank you.
Do we have any other questions out there, folks? It's about 20 minutes to the top of the hour. If you have a question, go ahead and hit *8 on your phone, and it'll show up on my screen, and I'll go ahead and unmute you. And if we don't have any other questions, then we'll go ahead and wind down for the night. Looks like we do have 3 callers, Christian, that just jumped on here that have a question. First one, I don't know if I say this right, Isaiah 555. You've been unmuted. Go ahead.
Yeah, this is Doug in South Carolina.
Hey, Doug. Hi, Doug.
Hi, Christian. I'm reading from the Social Security, the SS5 form, the instructions for other. It says if you check other, this is on page 2, if you check other, you must provide a document from the U.S. government agency that explains why you need a Social Security number and that you meet all the requirements for a federal benefit except for the number. And you're saying that the birth certificate is from a U.S. government agency and how do you explain why you need it?
I was prepared to go in there with a birth certificate. I had everything there, but they didn't even look at that block. They just put it right through it. There was no problems at all.
And they put it right through it with a copy. I mean, it was. Did you?
They didn't even read that form. They just typed it in the thing and sent me a new card.
Did you mail it in, Christian, or did you walk it there by person?
I walked it in.
Now, did you hand them a scanned-in color copy of your document while you kept the original?
Yeah, you go in like before, you get a copy, get the form from them, and then fill it out, in blue ink. Then get a color copy of that and give them back the copy the next day, say.
Oh, and you don't mark it as copy or anything?
No, I'm going to trick them and get it in there, and it doesn't make any difference. That's my counterpart.
Sure, yeah, right, okay. Yeah, I can print it off on the internet. It's downloadable PDF form, so.
Yeah, somebody told me that they tried that, but the form they got off the internet when they got in there was different from the other form that they had, and then they had to do the one that they gave them again, and it had some particular information on there they didn't want them to see or something. And
yeah, I heard that. But I'm going to try it with the one off the internet.
But I had no problem. When I checked the block and I put American in there, they didn't even question, didn't even read it at all, and I was, I didn't have to prove anything. They just.
But you got a brand new card in a few days.
Yeah, well, it took about 14 days, say, you get it back.
Okay. And I did get a call back from Miss Fitzgerald, and she said the certified copy of the Declaration of Independence was $30.
Yeah, I read that on the email you sent, yeah.
Yeah, so I'm waiting for her to reply with the instructions and how I can order it from her. She didn't tell me what form to submit, and there was no Form 72 on their site.
Don't we have something on the Free American site that to give instructions? I thought I saw that out there.
I was looking and I couldn't find it.
Chris or Harold, did you put that out there? I thought I saw that put out there just the other day.
No, I didn't.
All right, somebody did. I'll go take a look and I'll see what we got out there.
Okay, great.
By the way, with regards to what that gentleman, what Christian was saying about the person that had a slight problem with the download, that particular person was pre-1933. So I think that was a special incident, a special case. I think in most people's instances, the form off the internet will work. See, that person was pre-1933, so that's a different.
Correct.
Yeah, she said something about this. She had something that they told her that they weren't, that nobody else was supposed to see. I forget what she was going to try and see if she could get what that was.
Yeah, I'd be curious to see what that was also.
Yeah.
But I figure her case was a special case, being that she was pre-1933, and they needed a special form for her.
Interesting.
Very interesting.
Probably because 333 was some kind of special way they had to handle her for a reason.
Yeah, I think she may have certain claims and rights that people after 33 don't have.
Yeah.
Well, isn't that when the HJR went into play, and that's when all the trusts were created?
Right. She probably got under the wire for all this stuff and has been operating all these years, maybe, just on a totally different private realm. So it probably really hurt if she gets contracted back in that she does it with a restricted signature.
Yeah. Blackwater Flog, you've been unmuted. Go ahead with your question.
Hey, yeah, this is Kenny. I'm in Oklahoma at this point. I've called you guys before from California, but I'm not living there anymore. With regard to, Christian, you're talking about submitting this new Social Security application and signing by grantor and then signature. What had you done prior to that, though? Had you done something to revoke the previous Social Security number that had been assigned to your straw identity?
Yeah, I did something similar to that. We did an assignation of right on that and actually totally revoked it on a 521 form, but then you can recontract back over top of that and get back into Social Security just by filling out another form.
Okay, so if someone's... Now, let me make sure I understand here. The purpose of doing what you're doing is to be able to have this original Blue Ink signature application form signed as grantor as a piece of evidence to suggest that you are the grantor and not a trustee. Is that correct?
Yeah, that doesn't suggest that I am. That's proof that I am.
It proves that you are. Now, but in order for that to be valid, you would have to have done something to revoke the previous number that was assigned to you, right?
Not necessarily. It might be just that the current form takes precedence over it, and I could probably give them notification that of such of an effect.
Well, you're not getting a new number though. You're just getting a new card.
I'm not. I'm just same number just transfers over or spills over into this new agreement here. From time to time, I will modify this agreement, and I just modified it. Say.
Okay. So in essence, you wouldn't really need to go back and mess with anything before. Okay, this is not a totally new Sesticate. Basically, it's just
same number. Same numbers.
It's a renewing of. It's just getting another card, which we know now will have different numbers on the back than the previous card.
521 form totally got out of Social Security. When I did a FOIA on myself, they sent me back information. I don't exist.
And that's because of what?
I did a total process of revocation using a 521 form. We did a whole process on that. We notified all three branches of government: executive, legislative, and judicial.
I see. Interesting. Okay, I'll just one more quickie. I know you got another caller there, and you're trying to wrap this up. Is the Social Security agreement or the Social Security trust, is that a cesta-K or is that a statutory trust?
Both a cesta-K statutory trust.
Oh, it's both.
Yeah.
Are all cesta-K?
It was created in 1933, wasn't it? What was the date it was created? I forget. It's operating under statutes and codes.
So would that mean that all cesta-K trusts are in fact statutory as well?
No.
Okay. All right. I'll just have to do some more studying on that. All right. Great. Thank you.
So a quick overview of cesta-K. You can get off of Wikipedia. You'll see that cesta-K go all the way back to the 1600s, I think it was.
Can we trust Wikipedia?
Well, they give you references that you can bounce off of, so.
Okay.
Take it from there.
All right. Oh, great. Thank you.
All right. South Texas, you're the next caller. Go ahead with your question. You've been unmuted.
Thank you. Hey, Kristen, how you doing? This is Albert from Texas.
Albert, how are you tonight?
Oh, fine. How are yourself? You sound
Not too
good.
bad.
My question,
okay.
Kristen, is...
Go ahead.
Okay. My question is on guarantee with a Y. Now, there is quite a bit of definition to it. How does it apply to the Social Security Trust, if you will?
Yeah, I've been aware of the semantics there, but I haven't really checked it out.
Okay. All right, then my next question would be, just to recap what you were stating, you did an SS5, which is really what you were doing is just get another card, but you just did the rules of signatures on it.
Yeah, right.
Did you enter it in? Go ahead.
What was that?
Go ahead.
I was just doing that to establish the evidence to prove that I was grantor and beneficiary.
Did you deal with the county recorder's office in any way?
Oh, well, yeah, you would do a on a UCC1, you need two records or two witnesses or two registrations. And then also on a 3, if you wanted to move the title, then you also need 2 registrations or 2 witnesses for that also. Because you always have to have 2 witnesses to establish a fact, or 2 records. So the fact is I'm creating a title that I am the grantor. I'm creating the title that I am the beneficiary. And then I must first claim it on a UCC1, get it back certified copy. That's one record or one certificate, seal under a signature under seal, excuse me. And then I would go and put a notice into the county recorder, pull that out certified of the same thing. And then now I have created my 2 registrations, my 2 records. Now that proves the fact that I'm the grantor. Now I do this very same thing again with the beneficiary card. So I have 2 witnesses on each thing, proving that I am the grantor and proving that I am the beneficiary.
And then once you had your signatures and paperwork together, did you send it somewhere else?
Well, they're public records. Now, if I have a court action or something, then I would put it in, and notify the parties, due process.
Lately, we've been
now
studying.
That
Go ahead.
The evidence exists in the private, and I'm holding the evidence. And then there's where we do the CCI in chambers secret confidential commercial information in camera review.
Okay. We've been studying Form 1522, and what I'm wondering is this: the Social Security Trust has a guarantee, correct?
Yeah, there's a surety, and that's you.
Okay, there's a promise that that they make good on the consideration, and what I'm really what I want to state is this: is that the 1522 gets sent to two different addresses, and one happens to be a state in which the statute of guarantee is not enforced. So where there's other states, there could be a few other states that probably don't enforce it, but in this case, the 1522 is sent to two different ones, and one of the states is Pennsylvania, where the clause of the statute is not enforced, and when you do the 1522, and then with the technology that you just brought out to us today, sending it back to them, I think would, I think you could just terminate the Social Security connection that you have under statute anyway. What else it would do?
You're going to make the determination that you're the surety for that, but yet the security would still be in existence. Is that what you mean?
Well, by taking it, giving it back, you can possibly, theoretically anyway, take the statute, the laws of statute, off of your body.
Yes, because you're totally moving yourself out of the venue, yeah.
Well, anyway.
You're saying that the 1522 form is actually a way of moving the beneficial title back under the Social Security Administration trustee that merges the title and then terminates the trust?
Well, with your technology involved, yeah. That's what it looks like.
Mm-hmm.
But I'm not an expert here. You know, I'll wait and see if you ever look at the form carefully and see if the verbiage is that way.
Yeah, I really haven't looked at it again. I haven't had enough time. Sorry to say.
You know, with this, there's also the W-8 BEN and the W-8 IME forms, where you declare your status. So where here the guarantor is declared as a natural-born part of the land, part of the republic, and while the other two guys are the ones that they're looking at under statute.
Yeah, I see. Yeah.
Okay, Christian, thanks, man. You've done a real good job in explaining your trust. In the beginning, it sounded really, really terrible. But the more I listen to you, the more I'm getting it. Thank you very much.
Well, it's the basics that we lack, and that's why I'm really not bringing on any more advanced stuff, because what's the use? It's like you got the cart before the horse. How can you apply something that you don't know what you're doing to apply it?
Well, like last night, I think I brought up something that I might need to clarify. But see, what I think the problem with people like me, you know, we're kind of stupid, and we need identifiers. For example, in a traffic citation alone, just a traffic citation, something that a lot of people on the call might connect to. Who is the grantor? Who is the trustee?
Keep going.
Who is the grantor? Who is the trustee? Who is the beneficiary? Where do you see a trust in just being stopped and given a citation?
Aren't they just pirates acting under color of law, trying to push off unregistered securities on you?
Oh, yeah, that's without a doubt.
That's debtor creditor, yeah, but they really formed a trust, and now they're going to construe it that you're under the debtor creditor. So it's kind of like a bullfighter. You know, we're the bull chasing the red cape, and they just keep pointing that red cape wherever they want us to go. Now, we need to get a hold of the bullfighter, and if we ever got that notion in our minds, the bullfighter would be dead.
Well, I know that with your rules of signature, something like that happens, and we're prepared the way you have suggested. It might just overcome anything that might happen afterwards.
Yeah, you brought up a good point, because really what I was talking about earlier was, and in private here with some people, was that, we need to start thinking, hey, what kind of relationship do we have here? What is really going on? But then in order to answer that, we didn't know what these different types of relationships are.
Yeah.
Exactly.
Do we have an agency, or are we doing a fiduciary? Are we doing a debtor-creditor, or are we doing what? Or are we doing a trust? But if we don't know what these relationships are, then, it's very easy for them to trick us, because, no party in a trust needs to know or understand they're forming the trust, but yet it doesn't negate the trust. As long as the law recognizes the elements necessary for the formation of a trust, you've got a trust, even though no party, the grantor, trustee, or beneficiary, realized that they formed a trust. That's the real, because that's how they're getting you trapped, how they're getting you to volunteer for your signature, and then they construe you under debtor creditor, and you go to jail as a trustee, or you pay a fine according to trustee. So I think, yeah, you're right on thinking everything that we do day to day in our dealings with other people, we need to think, what kind of relationship are we forming here? Do we have a trust?
As you disseminate this information to us, you've got to pretend that you are the high school teacher and we're kindergarten. And in kindergarten, we needed identifiers. We needed little cards. Give us an identification, and I guarantee you a lot of guys that have been through the mush will start getting it, and they'll start understanding, because I think that's the only thing that's going to save us as a group to get out there and possibly start waking up other people. But we like me, man, I'm sorry, but I need identifiers. And once I get them, like in this case, you just told me some, and I'm starting to understand. Thank you.
Well, we're at the top of the hour here, and our call is typically for 2 hours. Do you want to keep going, Christian? I might get cut off. I might have to dial back in again. Otherwise, we can last two callers with questions on to next week's call.
There's two more left?
Yeah, let me bring it up here. Southeast Michigan. Go ahead. You've been unmuted.
Yeah,
so with us.
This is Lem from Detroit, Michigan. I have a question similar to what the gentleman asked about the traffic ticket. I'm trying to understand the relationships in the mortgage realm. I have, of course, an alleged mortgage, and I'm considering myself as a grantor or settlor. I had a mortgage with a company that is now defunct. They haven't been bought or sold. I actually found a case online where they actually had their rights to produce first and second mortgages pulled, I guess by some sort of federal agency. So I can't even find out who the actual alleged holder in due course is. In my original note, they stated that they were specifically going to assign the mortgage to City Mortgage, just the servicing, not the note, not the mortgage, but just the servicing. So I called City Mortgage and asked them, who is the holder in due course, since you guys just have the servicing. And I actually read the exact verbiage where it says that they were going to get strictly the servicing only. And the guy said, well, your note has been securitized and sold to investors. I said, wow, you're actually telling me this, huh? I said, okay. So now
there's got to be a trustee then.
I'm sorry?
There's got to be a trustee over that pool or that fund.
I don't know who would be that trustee. Would the servicer, the City Mortgage, be considered a trustee or the beneficiary?
If there was a securitization done, it had to be done according to SEC, and that means there are public records that exist in some place.
Okay, because I sent them a QWR form to see if I can get that information.
Go to Edgar and look up on Edgar's website and make sure you got your numbers at the time of the mortgage and the numbers and the QSIPs and things, and then see if you can track it that way.
Christian, would it be good for him to get his QSIP numbers for that mortgage?
Well, it might be good enough just for the loan number there, because I think Edgar is going to pertain to SEC, and the SEC was, your numbers of your mortgage.
You're saying you're able to look up your mortgage account numbers on Edgar?
Yes, because that's where it's got SEC filings from, and all banks had to have made SEC filings from the prospectus and everything.
So you can actually
documentation on it. They had to keep records of it. If they didn't, you can get them for that.
You can actually put your mortgage number in a search field in Edgar, and it'll pull up the trust that it's under?
I believe so, yeah. I haven't done it myself, but I know Edgar is one of the sites, or you go to the SEC site and look there. But, public documentation must exist for any securitization.
Okay, when you say Edgar, I'm not familiar with that. Can you give me
Edgar.com. I think it's Edgar.com.
Edgar.com, okay.
Just do a Google for Edgar and see what pops up, and then you'll find out it's probably Edgar.com.
And you're saying I can probably enter my loan number, huh?
Yeah.
Okay. The servicer would be the beneficiary, though, correct?
Not necessarily. The beneficiary on the note is the payee, who is the bank. Now, if the bank went defunct, there had to be somebody who got the assets, or somebody who might still be tied to that defunct agency.
Yeah, I can't get any information. I looked online. They're gone. Better Business Bureau, Dunn's. I mean, it's gone. I'm like, geez.
Well, who bought out their assets? Did they just settle for the assets and liquidate it, and they went defunct, or did somebody take over the liabilities and all that other stuff too?
Yeah, I don't know. I just was doing my research on it. I saw where they had a case where they had their licensing pulled for creating mortgages. So I was like, wow, okay. So I'm sure that I hit a wall. Like, bam, okay, I know who the service is. I know I'm writing checks to, or where I used to write checks to. But I can't figure. For the life of me, can't find out who is supposed to be holder in due course of this thing. But I've gone through the process of doing a right to cancel, power of attorney, rescission of power of attorney, and removal of trustees. So I think I'm going through the right administrative steps. But in learning and hearing about this new trust, I sort of said, well, man, this is a trust. Yeah, it's an express or implied trust. So I'm trying to understand, like you say, you got to find out who the positions are, who the players are in this trust that I'm trying to establish as a legitimate trust. And I couldn't answer those questions. So, okay.
Just express the trust, step 1. Step 2, merge the titles. Step 3, collect on the disbursement.
Okay. Correct on disbursement.
Step 1, you're going to establish that you're the grantor creating the whole thing. And what you're going to do is you're going to call the note back.
Right. Once I find out who's supposed to have the note.
Call the note back or give me the proceeds, one of the two. And if not, we got a problem.
Okay.
Merge the titles. And once you merge the title, then the funds should transfer from one side to the other side, and the mortgage should be paid at that time. Should get the house free and clear, and then go after the securitization funds on the note, which are the investments and the proceeds that your note generated. Go after those, because those are in addition.
GSA form, not GSA, those forms. I've read some of your other posts, some of the text from your other stuff, but that was forms, right, where you actually do a claim of claiming. There's official forms to do that with, right?
Yeah, we use the GSA forms for claiming and moving and creating the titles, yes.
Okay.
And the UCC.
Okay, because I do have a UCC on it. I did that already using Tim Turner's process, and I claimed the property under UCC, so I do have that completed.
Yeah, but see, that's only under debtor creditor, but it's not under trust.
Right. Like I say, I just got wind of this new trust technology, so it's almost been like a concurrent learning path, doing that and also learning this new trust technology. So got a lot of learning to do, but it's a good opportunity.
The trust, 800-pound gorilla that nobody knew that they were. And you allowed them to put on a gorilla suit looking like a 900-pound gorilla and scared you because, but they really weren't. You are. You're the 900-pound gorilla. You just never expressed the trust. So now you allowed to construe it. Now they put you under debtor-creditor law back under UCC with a 30-year mortgage contract on an unconscionable contract that you were going to make payments to them in case you didn't pay them at closing.
Right.
But you did pay them at closing, except you never told them to do the switch on those reledgering from one side to the other.
Right. Okay.
And they're sitting there forever waiting on your grantor's instructions to them being a trustee, and then they're never getting the instructions, and they say, hey, this guy abandoned the property. Let's go ahead and invest all these funds and do this and do that. And if he shows up, well, we'll settle things later.
Okay.
First, express the trust, step one. And then merge the title, step two. And then you can collect on the disbursement of the funds, step three.
Okay. You say merge the titles. That means from the different positions, me grantor and me beneficiary?
Anytime both titles are found in one entity of the trust terminates.
Okay.
So if the trustee has the legal title and I move the beneficial title from the beneficiary and assign it to the trustee, now he has both titles and the trust terminates. And then upon termination of the trustee no longer has the protective covering of the trust, and he becomes personally liable at that point. And now he must complete the trust duties and wind up the trust by dispersing the funds to the beneficiary.
Gotcha. Okay. And I use my UCC 3 to move it again. So I have the 1, now I do the 3.
Yeah, 1 claims it, 3 moves it.
Okay. And the NOI and the SOI, I should send a notice to each one of those parties. I know who the servicer is, but I just got to find out who this holder in due course is. So,
are you under the process that you got to complete?
I'm sorry. Can you say again?
Are you under the gun in a process you have to complete by a certain date?
I think I have. They graciously gave me a 90 days. I told them I didn't want their 90 days, but they gave it to me anyway.
You got a limited time then, because my suggestion was if you don't have a specific date that you got to do something by, that you take your time and study this stuff and get to know all the A through Z about it first before you go out there and do it.
I figure I have at least, another 45 days. So
that's not a whole lot of time, so,
Yeah. Okay, I'm cramming as much as you can give it. I'm trying to get it. I like to read stuff, so I've been finding all your stuff online and trying to read it. So,
well, I'm trying to get some of the details wired out on the workshops, and I'm going to announce the workshops here probably by the end of the week here.
Oh, awesome. Well, I'm definitely on board.
The workshops can be accessed from anywhere in the world. It'll be a conference call with, by computer, so we can. We're actually going to be constructing the documents. We're going to know the basics. So when I get that announcement, if you have sent me an email, so I got you on record. So when I do the announcement, you'll get the email blast.
I've already done that and anxiously await that. So I appreciate it, man. Thanks for your help.
Christian, we can also post that information out on the Free Americans Yahoo group as well. We can shoot that information out about the workshops you're putting together. All right, we have Blackwater Frog. Looks like you had one last comment here. Go ahead, you've been unmuted.
Hey guys, just back to that whole process on the SS application to establish the status of grantor. When you talked about making a claim on a UCC1 and making a county record, did you mean just noticing the form, or you're not talking about actually filing the form itself with the UCC or filing the form at the county level, are you?
Never file the form because you're going to give it back to them. Yeah.
Right.
All I'm going to do is a notice filing, which is really what a UCC1 and a 3 really is.
Right.
It's just notice of a lien, say, or a notice of.
So what you would do at the county, in the county record, is just make a record of an affidavit saying that this other document exists.
Yeah, I just give a notice. This is actual and constructive notice of a such and such an instrument held in the private, such and such a specific number to identify it, and it's in the private. If you want to see it, contact so and so, and if he gives it to you, well, okay. If not, well, you've had notice. You need to check into it.
Okay, great. All right, thanks, guys.
Nothing technical is mentioned in the public about it other than it existed in the private.
Okay, gotcha. All right. Hey, great. I really appreciate the show this tonight. It's really great. Good stuff. I'll be reviewing this. Well, hey, you guys, when is this going to be posted up so we can review it? Do you have any idea how long that takes?
What are you referring to? What are you referring to?
This call tonight is can we access this recorded?
Yeah, you sure can. It takes like maybe 20 minutes before it pops up.
Oh, so 20 minutes after it completes tonight, it'll be up?
Yep.
On TalkShoe.
That's correct. Yep, 41875. Just go out to 41875, and it'll show all of the recorded calls.
Okay, great. All right, thanks, guys, very much.
All right, folks.
All right. Bye-bye.
Be sure to remember the Christian Saturday night call. It's, every Saturday night at 7 p.m. Moving Money, Banking, and Trusts by Moving Titles and Commerce. And that's at 7 p.m. Eastern Time. And I'll give you that number again real quick. It's area code 712-432-8773. The PIN is 179441#. You can also access that information at therealpublicradio.net. Thank you so much for being on the call tonight, and we'll talk at you next week, same time. Have a great evening, everyone.
Okay, thanks, Matt.
Thanks, Christian. Good night.
Night all.
Good night.